Good morning. In today's lecture, we shall be discussing the approach of law as taken by H.L.A. Hart. In order to better understand the concept which is given by H.L.A. Hart, it is important to discuss the comments that are given by other legal philosophers that are not sympathetic to legal positivism. Generally, natural law asserts several principles that are irreconcilable with legal positivism. Most importantly, natural law finds that there is a necessary, not a cognate relationship between law and morality. According to natural law theory, when there is conflict between natural law and human law, natural law that should take over. In this regard, natural law dictates that all human made laws must be in accordance with fundamental natural principles, such principles that promotes common good. Thus, when we discuss about natural law theory, it is believed that all laws must be morally justified if they have to be legitimately called law in its true sense. It is at this point that differentiate the rationale behind natural law school and analytical school of jurisprudence. We have already discussed the theory that is given by Austin under analytical school of jurisprudence. When we talk about the theory that is given by H.L.A. Hart, he explains that Austin fails to explain that what is the difference between being obliged and being under an obligation. And as per H.L.A. Hart, a legal system is not one that is created by the command. As per H.L.A. Hart, in Austin theory, a person is obliged to follow orders. There is no duty or obligation, but orders are followed due to evil consequences, and such orders are coercive in nature. These are such duties which are not created but are imposed on the citizens. Whereas H.L.A. Hart believes that the duty is one which is created by mutual consent, and the consensus which is developed is called rule of conduct. And every party has the common advantage and is benefited by the command. To say, for H.L.A. Hart, laws are the rules which are created by psychological, emotional consent of the people of the society. This creates a duty on every person to follow such orders because they are created by consent and for the benefit of all. H.L.A. Hart has discussed his theory in his book called The Concept of Law. According to H.L.A. Hart, law is a system of rules, and these rules include primary rules and secondary rules. These primary rules are the rules that are created through interaction among people and thus confer duty among the members of the society. To say what conduct is to be done is based on consent within and among the members of the society. Such rules that are drafted are consensual in nature. However, there exist some problems with primary rules. H.L.A. Hart has explained these problems as how to identify the primary rules, how to adjudicate these primary rules, how to change these rules. To say, H.L.A. Hart believes that there are primary rules that are made on the basis of consent of the members of the society. But when these rules are made, there are certain problems that comes up before the members of the society that relates to the concept to the problem of identifying, the problem of adjudicating these problems, these rules, how to adjudicate them, and how to change these rules. Thus, in order to find out a solution to these problems that emerges out of the primary rules, H.L.A. Hart believes that there are certain secondary rules that are drafted in order to provide solutions to primary rules. And these rules are the rules that confers power to identify to an authority. The second are the rules that are created for conferring power to adjudicate. And lastly, there are rules that are laid out for the purpose of conferring power to change. These rules are classified as secondary rules by H.L.A. Hart and are seen as the possible solution to the problems that emerges due to the primary rules that are based on the consent of the members of the society. Thus, for H.L.A. Hart, a legal system is a union of primary rules and secondary rules, where primary rules lay down and reflects the opinion of the members of the society, and secondary rules find out the possible solutions to these primary rules that are framed after consenting the members of the society. To explain further the concept of primary rules, as per H.L.A. Hart, these are those rules that regulate the behavior of the members of the society. These rules either grant rights or impose obligations on the members of the society. Like, for instance, rules of criminal law that forbids murder, robbery, rash driving, and other types of offenses that an individual may commit. Others are like tort rules, where one individual cannot commit any kind of civil wrong towards another individual. Other examples include right to freedom of speech, the provisions relating to contract, where the obligations of parties are defined, environmental laws that regulate the conduct of an human being towards the environment, where it defines the duty of an individual or a person who is a member of the society to protect and preserve the environment. Thus, for H.L.A. Hart, primary rules are the rules of conduct that tells you what you are legally obliged to do or refrain from, and what consequences attach to obedience or disobedience of a particular conduct. Whereas, while talking about secondary rules, H.L.A. Hart has focused on the concept as to who shall formulate these rules. Who are these recognized bodies and authorities who are given the power to make the rules? Secondary rules have been defined as rules that confer powers on the authorities. And these powers that are conferred are mainly for the purpose of identifying the rules, for the purpose of adjudicating the rules, and for the purpose of changing the rules. While talking about these three rules, it has reflected the three pillars, that is, the executive, judiciary, and the legislature. These authorities are such authorities that lays down the rules on the basis of which primary rules are framed, and an individual or a member of society tends to conduct himself or herself in a given mode. Thus, while talking about the difference between primary rules and secondary rules is a very thin line of difference. The difference that exists between duty imposing and power conferring rules. Duty imposing rules are such rules that confers duties on the members of the society to perform in a particular manner, whereas power conferring rules confers powers on the authorities to make such rules that regulate the conduct of an individual. But when these secondary rules are framed by the authorities, where that reflects the primary rules, the opinion, the consent of people is taken into consideration on the ground that these rules are framed for the benefit of all and for the members of the society. After understanding the theory that is given by H.L.A. Hart, it is important to understand the importance of the theory given by H.L.A. Hart. When we talk about the importance of H.L.A. theory, the theory given by H.L.A. Hart, it is important to analyze this aspect, the aspect that H.L.A. Hart has focused more on the opinion, on the consent of the members of the society. H.L.A. Hart had reflected that the primary rules that are framed for the benefit of members of the society. And it is here where H.L.A. Hart has deviated from the concept which is given by Austin. Where Austin has created a monarchy setup, H.L.A. Hart believed in creating a more social welfare state that reflects the consent of people, that reflects the benefit of people, of member of the society. He has further emphasized upon the concept of duty than on the concept of obligation. Hence, for Austin, a legal system is a combination of primary rules and secondary rules. These are such rules that are conferring duties on the members of the society, and these are distinguished from the other rules in that they are supported by great social pressure because they are felt to be necessary in order to maintain any social order in the legal system. Where the theory given by H.L.A. Hart has bring out a positive factor under analytical school of jurisprudence, there are many criticisms that have also been taken up under the theory given by H.L.A. Hart. Talking about the criticisms of H.L.A. Hart, Hart's concept of law does not account for a distinction between a club and a state. A club exists within a state, but a state does not exist within a club. State is like a building, club is like a room. The system which prevails in a club and in a state exhibits the same characteristics for H.L.A. Hart. What is needed is some means of identifying this difference between club and the state or the law of land. The difference thus lies in the nature of institution. As a club is an institution, so is the law and the legal system. It is the difference that should be made should be at the institutional level in order to find out a distinction between a club and a state. It has been further stated, like in a club, there are opinions of the members of the club taken into consideration. Similarly, in the state, the opinion is taken into consideration for the benefit of all. Thus, it is here where Hart fails to make out a distinction between the institution called club and the institution called legal system. Second important criticism of H.L.A. Hart is that its concept is based on the distinction between primary rules and secondary rules. Primary rules that are creating duties and secondary rules that are creating power. But it is questionable whether there is a sharp distinction between the two. Is it possible to make out a distinction between primary rules and secondary rules? Because it is possible that there are certain rules that are creating duties as well as power on an individual or the member of the society. To say, in a given legal system, there may exist some rules that may create a power as well as duty to exercise that power, or a power as well as duty not to exercise the power. It has failed to make out the distinction between the primary rules and secondary rules. Next important criticism of H.L.A. Hart theory is that there are certain rules that are not conferring duties, but instead they abolishes one's duties. Like for example, a contract which is discharged by frustration. Such a rule is neither power conferring nor duty conferring. Here, to refer to Section 56 of Indian Contract Act, it is that provision that abolishes the duty of an individual or a member of the society with respect to the contract that get frustrated. Due to these reasons, it is believed that the concept which is given by H.L.A. Hart fails to make out a distinction between law and legal system, and thus the relationship between law and legal system remains blurred. Though H.L.A. Hart is a theorist who belongs to an analytical school of jurisprudence, but the approach which is given by H.L.A. Hart differs from the theory given by Austin in many sense, especially on the basis of the concept of command as given by Austin. In our previous lecture, we have discussed the concept of law as given by Austin, and today's lecture we have discussed the concept as given by H.L.A. Hart. I hope the listeners were able to understand the concept as given by H.L.A. Hart, and I shall appreciate the comments or any doubts that the listener may come up with that shall be taken up in the next class. Thank you so much. Have a nice day.